Have you ever wondered what makes a formal relationship, like a marriage or even a civil partnership, legally valid here in the UK? We hear so much about divorce, but what happens if, right from the beginning, there was something fundamentally, well, wrong with how the relationship was formed?
It's a really fascinating area of law, isn't it? While relationships and, family structures have changed quite dramatically over the decades, particularly with cohabitation being so much more common,
Right.
marriage and civil partnerships still hold this unique and pretty critical place in English law. They define rights and responsibilities in a really profound way.
Absolutely. And the law has these very specific rules about what conditions have to be met for these formal relationships to even be recognized as valid. So that's what we're diving into today, the formation and validity of marriages and civil partnerships under English law, focusing specifically on what makes them invalid, what the law calls nullity.
hmm And this deep dive we're doing, it's based on educational materials made available to students, specifically excerpts from Topic 2 Marriage and Civil Partnerships provided by the University of London.
Okay.
We want to be really clear that this exploration is purely for educational purposes. It's brought to you by Sinorbit Academy, Sri Lanka. And to all of you listening, particularly if you're gearing up for exams on this topic, we sincerely wish you the very best of luck.
Yes, good luck. So our aim today is to unpack the legal requirements for forming a valid marriage or civil partnership, explore the specific grounds that can lead to a declaration of invalidity, being declared void or voidable, and look at the significant consequences that follow such a declaration.
Exactly. And to navigate this effectively, we really need to get a handle on some core concepts right from the start.
Right.
The distinctions between a void marriage, avoidable marriage, and this separate category the courts have identified called a non-marriage. Well, they're absolutely fundamental to understanding this whole area.
Okay, let's really get into it then. We touched on the social shift since the 60s, less pressure to marry, more people living together without those formal ties. But the law hasn't just abandoned marriage and civil partnership, has it?
Not at all. It still provides a very clear legal framework for those who choose that route. Essentially, the law requires two adults who meet certain formal requirements and, crucially, have the legal capacity to marry or form a civil partnership.
And if those fundamental requirements aren't met?
Well, that's when the relationship might be legally challenged, and that's precisely where the law of nullity comes in.
Right, it's the legal mechanism for saying, okay, despite maybe a ceremony or some registration, this formal relationship isn't actually valid according to the law. It sort of defines the valid state by outlining the invalid ones.
That's a great way to put it. It sets the boundaries for what the state recognizes as a formal union. And nullity, it falls into two main categories: void marriages and voidable marriages.
Okay, so what's the key difference? Let's start with void marriages. What are they?
A void marriage is one that the law treats as having been invalid right from the very beginning. It's essentially as if it never happened in the eyes of the law.
Never existed legally.
Precisely. It has no legal effect, and no legal status is created by whatever ceremony or registration took place.
Okay, so null and void ab initio, right from the start. Got it. And avoidable marriage.
Now voidable marriage is quite different. This is a marriage that is treated as valid by the law unless and until a court actually makes a decree of annulment.
So it's real until a court says otherwise.
Exactly. There was some kind of defect at the time of the marriage, but the law treats it as a subsisting, legally recognized marriage until someone successfully challenges it and the court issues that decree.
So one is never was and the other is was until undone by a judge. That distinction feels really, really significant.
It truly is fundamental, and these differences, they have real practical implications. Lord Greenamar explained these key distinctions very clearly way back in the case of de Reneville v. de Reneville in 1948.
Okay.
Yes, and his points are still absolutely central to understanding nullity today. We should probably break those down.
Let's do it.
Yeah.
What's the first big difference from de Reneville?
Okay, the first is about the timing when you can actually seek a decree of nullity. For a void marriage, a decree can be pronounced at any time. It could even be after the death of one or both parties.
Really? Even after death?
Yes, because it's just confirming a legal reality that always existed, that, legally speaking, no marriage ever actually occurred.
Okay, but that's different for avoidable marriage.
Very different. For avoidable marriage, a decree of annulment can only be granted during the lifetime of both parties. Once one of the parties dies, the chance to annul that voidable marriage is gone.
Right, so timing and whether both parties are alive matters hugely for avoidable, but not really for void. What's the second distinction from Durenville?
The second relates to the status of the relationship before any decree is made. A void marriage, as we said, is treated as if no valid marriage ever existed right from the start. It's a legal nullity from day one. A voidable marriage, on the other hand, is treated as a valid subsisting marriage unless and until a court issues the decree of annulment.
Right, so the voidable marriage does create a legal status, at least for a time, but that status can be revoked. The void one never did. And the third key difference mentioned in Durenville.
This is about who has the legal standing or who is allowed to bring nullity proceedings. For a void marriage, proceedings can be taken by any interested person.
Any interested person, so not just the couple.
No, it could be one of the parties, certainly, but potentially a third party, too, maybe a relative who has a legal interest, perhaps concerning inheritance or property rights, for example.
So if someone's claiming inheritance as a spouse from what might be a void marriage, another family member could challenge that marriage's validity to protect their own interest.
Precisely. But for a voidable marriage, proceedings to annul it can only be taken by one of the parties to the marriage themselves. A third party, like that relative, has no standing, no right to seek annulment of a voidable marriage.
Okay, those 3 points from Durenville really lay the groundwork. Let me see if I've got this. Timing void anytime, even after death. Voidable only during joint lifetimes. Status void never valid. Voidable valid until annulled. Petitioner void any interested person. Voidable only the parties.
You've got it. Those are the crucial distinctions to keep firmly in mind as we go through the specific grounds. But as we mentioned earlier, English law has sort of added another layer to this picture in more recent years, the concept of the non-marriage.
The non-marriage. Okay, that sounds like it doesn't even get close enough to be considered a defective marriage in the first place.
That's precisely the idea. This category applies to ceremonies that fail so fundamentally to comply with the essential legal formalities that the court basically concludes they were never even intended to create a legal marriage. Or maybe they're just so deficient they aren't capable of being recognized as a marriage attempt under the relevant law, the Marriage Act.
Where did this concept really emerge from? Was there a key case?
Yes, it gained real prominence in the case of Hudson v. Lay back in 2009. You had parties who went through a religious ceremony in South Africa.
Okay.
But their intention was that this was purely a spiritual blessing, a commitment ceremony, before they came back to the UK for a formal civil marriage. Problem was that civil marriage never actually happened.
Okay. So when the relationship broke down, the status of that South African ceremony was questioned.
Exactly. And Mr. Justice Bodie concluded it couldn't be a void or voidable marriage under the Matrimonial Causes Act 1973 because it simply didn't purport to be the legal marriage ceremony required by that act. He called it a non-marriage or a non-existent marriage. He suggested the court has to look really closely at the specific facts of each questionable ceremony.
And he gave some factors for courts to consider, didn't he? What were those key things to look for when deciding if something is a non-marriage?
He listed 4 points as helpful guidance, though he stressed it wasn't a strict checklist. First, did the ceremony set out or purport to be a marriage? Was it presented as a marriage? Second, did it bear all or enough of the hallmarks of marriage? Things like, witnesses, formal vows, or commitments being exchanged, someone officiating.
Right, the kind of things you'd expect to see. What else?
Third, and he put quite a bit of emphasis on this one, did the 3 key participants, that's the 2 parties, and importantly, the officiating official, did they all believe, intend, and understand the ceremony as giving rise to the status of lawful marriage under English law?
The officiant's understanding seems key there.
It seemed very important in Hudson v. Lay. And fourthly, what were the reasonable perceptions, understandings, and beliefs of the other people who were actually there, the attendees?
But I think we saw a slightly different emphasis in a later case, didn't we? Something about the party's intent maybe being more central.
Yes, that's right. In MAVJA in 2012, you had an Islamic ceremony, a nikah, that took place in a registered building.
Yeah.
Crucially, the parties did intend to contract a legal marriage, and the court found it was a valid marriage, despite the imam apparently lacking the intention to perform a specifically legal ceremony recognized by the state. So this suggests the party's own intention and, importantly, the use of a properly registered venue can sometimes be enough, even if the officiant doesn't fully grasp or intend the legal ramifications.
It's definitely a case-by-case assessment, weighing up these Hudson v. Lay factors, but the intention of the couple getting married and whether it had some of the proper legal Hallmarks like a registered place seem very important.
Exactly. And this is an area that is definitely still evolving legally. The whole saga around the Octave Khan case is a prime example of this ongoing development.
Yes, I remember that. Initially, the High Court in Octave 2018 found that a religious-only ceremony, the nikah in that case, which wasn't compliant with the Marriage Act, could potentially fall within the scope of the Matrimonial Causes Act 1973. That would have allowed access to nullity remedies, wouldn't it?
It would have, yes. But that decision caused quite a stir and was overturned by the Court of Appeal and Attorney General V. Actor and Khan in 2020.
Okay, what did the Court of Appeal say?
They held that a nikah ceremony, which was never intended by the parties or the officiant to be the legal marriage ceremony required by the Marriage Act, could not be a void or voidable marriage under the Matrimonial Causes Act. It fell outside that statutory framework.
So back towards the non-marriage idea for ceremonies that don't comply.
Essentially, yes. However, interestingly, the Court of Appeal did allow the applicant in that specific case, Mrs. Actor, to seek other remedies because of the very unique facts and the potential injustice she faced. So it shows the courts are still grappling with how to deal fairly with these non-statutory religious ceremonies that don't fit neatly into the voidable boxes.
And the practical consequences if a ceremony is declared a non-marriage, quite severe, aren't they? Especially financially.
They really are. The most significant one is that because it's not legally recognized as even an attempt at marriage, the parties have no access to the comprehensive financial remedies available upon divorce or nullity under the Matrimonial Causes Act 1973.
Wow. So no spousal maintenance, no ability to claim a share of assets acquired during the relationship under those specific matrimonial rules.
None of that. It can leave a financially weaker party in a very, very vulnerable position compared to someone ending a void or even avoidable marriage.
That's a huge difference.
It is. It's worth remembering, though, as we saw in Ms. Hudson's case, Hudson v. Lee, that financial relief for the benefit of any children from the relationship can still be sought. That's under Schedule 1 of the Children Act 1989.
Okay, so the parties themselves lose out on financial claims against each other, but the children can still be provided for.
Yes, that protection for children remains available.
Right. So to quickly recap this spectrum of invalidity we've discussed,
Yeah.
a non-marriage is a ceremony that doesn't even get over the starting line to be considered a legal marriage attempt.
Right.
A void marriage is legally non-existent from the very start because of some fundamental legal defect, like being too closely related or already married.
Yes.
An avoidable marriage is legally valid until a court pronounces it annulled because of the specific defect present at the time, like lack of consent or inability to consummate.
That's the essential hierarchy in English law. You've got it.
Okay, but why do we even have nullity law today? You know, with divorce being much more accessible now than it used to be, why not just use divorce to end any relationship that isn't working?
That's a really good question. Historically, nullity was incredibly significant before the Divorce Act of 1857.
Right, the one that set up court-based divorce.
Yes, before that, getting a divorce required a private act of parliament that was hugely expensive, prohibitively so for most people. So nullity proceedings were often the only practical way to legally terminate a marriage.
So if you were trapped in an unhappy marriage, you basically had to try and find a reason why it was invalid right from the outset, rather than argue it had broken down later.
Pretty much, yes. And now in the modern era, things changed dramatically with the Divorce Reform Act 1969, which brought in irretrievable breakdown as the sole ground for divorce, making the process much simpler.
And that's made nullity much less common.
Far less common. If you look at statistics, say from 2019, there were only 297 nullity decrees granted in England and Wales. Compare that to over 107,000 opposite-sex divorces in the same year.
Wow, 297 versus over 107,000. That huge difference really shows how niche nullity has become. So what role does it actually serve today? Why keep it?
Well, it arguably still serves several purposes. Firstly, it provides clarity on the legal requirements for entering into a formal union. It spells out what makes a marriage or civil partnership valid by defining these invalid categories.
It defines the boundaries.
Exactly. Secondly, for some individuals who have strong cultural or religious objections to the concept of divorce, nullity can offer an alternative way to legally end a relationship. They can argue it never truly existed in the eyes of the law, which might be more acceptable within their belief system.
I see. So it's a legal option that kind of sidesteps the idea of dissolving a union that was considered validly created.
Precisely. However, there is an academic debate about this. Legal scholars like Cretney and Probert, for example, have argued that the grounds for voidable marriage, in particular, should perhaps be abolished.
Really? Abolish voidable marriage. What's the argument there?
The argument is that many of the grounds for voidable marriage, things like incapacity or refusal to consummate, or certain types of lack of consent, or mental disorder making someone unfitted, relate to issues that arise or become apparent after the marriage, or concern a party's fitness for married life generally.
Okay.
And they argue these issues are actually better addressed by the law of divorce, which is specifically designed to deal with the breakdown of what was, initially at least, a valid marriage. They suggest the state's interest should maybe be limited to ensuring the validity of the formation of the marriage, covering the void grounds, and perhaps leave the religious or personal status issues to religious bodies or the individuals themselves.
That does make a certain amount of sense. If the issue is, say, refusal to consummate, maybe that's just strong evidence the marriage isn't working and should be ended by divorce, rather than being treated as a defect that existed right at the moment of marriage.
It's definitely a live debate about the purpose and ongoing necessity of these, sometimes quite historical grounds in our contemporary legal system.
Okay, fascinating debate. Let's turn our attention now to the specific grounds that make a marriage void. You mentioned earlier that Section 11 of the Matrimonial Causes Act 1973 provides the exclusive list for marriages celebrated after 31st July 1971.
That's right. Section 11, often written as S.11 MCA 1973. If a marriage celebrated after that date falls under any of the grounds listed in S.1, it is automatically void. Treat it as if it never happened, legally speaking.
So what's the first ground? That's S.11AI, prohibited degrees of relationship.
Right. This covers relationships considered too close for marriage, either by blood, that's consanguinity, or by marriage, which is affinity. The full, detailed lists are set out in Schedule 1 of the Marriage Act 1949. These obviously include close relatives like parents, siblings, grandparents, children, aunts, uncles, etc.
And this gets complicated with adoption, doesn't it?
It does. Under the Adoption Act 1976, an adopted child is still prohibited from marrying their natural parents or certain other natural relatives. And very importantly, an adoptive parent and their adopted child are also within the prohibited degrees they cannot marry each other.
But adoptive siblings can marry.
Yes, adoptive siblings are not prohibited from marrying each other.
Okay. What about relationships created by marriage, like step-parents and stepchildren? That must have specific rules.
It does, and this is where it gets quite specific and frankly a bit complex. You can marry certain relatives by affinity, but only under very strict conditions. For marrying a stepchild, for instance, both parties must have been over the age of 21 at the time of the marriage.
Both over 21.
And crucially, the stepchild must not have been a child of the family in relation to that step-parent at any time when the stepchild was under the age of 18.
Right. So if a step-parent married the child's parent when the child was, say, 15, and living with them as part of the family, that step-parent could never marry that stepchild later on, even once they're both adults over 21.
That's correct. The law is trying to prevent a marriage where there was previously that kind of parent-child dynamic during the child's formative years under 18. The policy behind it is about avoiding confusion in family roles and protecting potentially vulnerable younger individuals from relationships that might exploit a prior parental connection.
Makes sense. Okay, the next void ground under S.1 is S.11A, which relates to age.
Yes. A marriage is void if either party is under 18 years old. This age was, as you know, recently raised from 16. The Marriage and Civil Partnership Minimum Age Act 2022 made it illegal for anyone under 18 to marry or enter a civil partnership in England and Wales, even if they had parental consent. It effectively abolished child marriage here.
And this rule, this minimum age of 18, it can't just be bypassed by popping abroad to get married where it might be legal at a younger age.
No, absolutely not. At least not for anyone who is domiciled in England and Wales. It's an absolute rule. The case of Pew v. Pew back in 1951 demonstrated this very clearly.
Pew v. Pew, what happened there?
Well, you had an Englishman domiciled here in England who went to Austria and married a 15-year-old Hungarian girl. Now, that marriage might have been valid under Austrian law at the time.
Okay.
But when it came before the English courts, they held the marriage was void. Why? Because the husband was domiciled in England, and English law prohibited marriage under 16 then. It's 18 now. That English rule applied to him regardless of where the ceremony took place. So you cannot evade the minimum age requirement by marrying overseas if you are subject to English law through domicile.
Okay, so prohibited relationships and being under 18 are fundamental barriers making a marriage void. The third void ground is SPIN 1A3, which is about defective formalities. This sounds complicated.
It is historically significant and, yes, currently quite complex. It dates back to Lord Hardwicke's Marriage Act 1753, which was introduced primarily to stop secret or clandestine marriages by requiring things like a public ceremony, witnesses, and proper registration.
That sounds like a sensible aim, but you say it's complex today.
The current law is spread across various statutes, mainly the Marriage Act 1949, and reflects historical compromises and accommodations for different religious groups, alongside the later development of purely civil marriages. The Law Commission is actually reviewing this whole area right now.
Oh, they are?
Yes, they've acknowledged the current law is often difficult to understand and administer, and they're proposing reforms aimed at simplifying the rules around venues, the form of ceremonies, and even costs.
Okay, so what kind of formalities are generally required now before those reforms happen?
Well, broadly speaking, there are preliminaries that happen before the ceremony and then requirements for the ceremony itself. The preliminaries are mainly about giving publicity to the intended marriage and allowing time for any legal objections to be raised.
What sort of preliminaries?
For Anglican marriages, Church of England or Church in Wales, this might involve publishing bans or obtaining a special or common license. For civil marriages and most non-Anglican religious marriages, the parties need to give formal notice to a superintendent registrar and then obtain a certificate, usually after a waiting period, often 28 days. This notice process is also increasingly used as a tool to help identify potential sham marriage they entered into, primarily for immigration advantages.
Right. The waiting period gives time for investigation if needed. And the ceremony itself, what are the requirements there?
They vary depending on the type of ceremony. Anglican ceremonies follow the rites of the Church of England, must take place in a church or other authorized Anglican building, and be conducted by authorized clergy. Same-sex marriage is not currently permitted within the Church of England or Church in Wales rites.
Okay. What about civil ceremonies?
Civil ceremonies must be entirely secular, no religious content allowed. They are conducted by a superintendent registrar and a registrar, usually in a register office or an approved premise. Think licensed hotels, stately homes, etc. Crucially, they must include specific prescribed words where the parties declare they know of no lawful impediment to the marriage and then take each other as husband and wife, or wife and wife, or husband and husband.
Those specific words are essential.
Absolutely essential for a valid civil marriage. The ceremony must also take place with open doors and have 2 witnesses.
And religious marriages outside the Anglican Church.
Marriages can take place in other registered places of religious worship, like mosques, synagogues, temples, nonconformist churches, but they must follow the civil preliminaries, giving notice. The ceremony needs either an authorized person from that religious body present or a registrar. And again, critically, the parties must include those prescribed legal, declaratory, and contracting words at some point during the ceremony, even if the rest is religious in nature. Same-sex marriage is possible in these venues, but only if the specific religious organization and the individual officiant have opted in to conduct them.
What about groups like Quakers or Jewish communities?
They have historical exemptions. Their marriages are governed by their own specific usages, but still require the civil preliminaries notice beforehand.
So lots of specific rules about where you can get married, who has to be there, and what must be said or signed. What happens if some of these rules are missed? Does a mistake automatically make the marriage void?
No, and this is a really, really important point to grasp. The law actually bends over backwards quite a bit to try and uphold marriages where the parties genuinely intended to marry, but some procedural error occurred. Most failures to comply strictly with all the formalities do not automatically invalidate the marriage.
Okay, that's reassuring for people who might make an innocent mistake. So when do defective formalities make a marriage void under S11A3?
The marriage is void on grounds of defective formalities only if both parties knowingly and willfully disregarded certain core requirements. Sections 25 and 49 of the Marriage Act 1949 are the key provisions here.
Knowingly and willfully, both parties.
Yes, both parties must have deliberately ignored specific fundamental requirements. These usually relate to the venue, for example, marrying somewhere completely unauthorized, the notice requirements, deliberately marrying without giving any proper notice or obtaining the necessary certificates, licenses, or the celebrant, marrying without any authorized person or registrar present when one is required.
So the critical element is the knowledge and intention of both people getting married regarding these core legal necessities.
Exactly. If they genuinely believed they were following the correct procedure, perhaps misled by someone else, or if only one of them knew about the defect, or if the defect was minor, the marriage is unlikely to be void on this ground.
Can you give us an example from a case to illustrate this knowingly and willfully part?
Sure. Look at Group Nisveh Yaqub from 1997. In that case, the parties went through a ceremony in a Coptic Orthodox church. They knew perfectly well that they hadn't given the proper legal notice, they knew the church wasn't registered for marriages under the Marriage Act, and they knew the priest officiating wasn't authorized under that act either.
So they knew about multiple serious defects.
Yes, they were fully aware. Because both parties knew about these fundamental defects and deliberately proceeded anyway, the court held the marriage was void under what's now S1A3. They had knowingly and willfully disregarded the core requirements.
They knew and willfully went ahead despite ignoring the rules. Got it. How does that contrast with a case where they didn't know?
Well, contrast that with Chief Adjudication Officer v. Bath in 2000. This involved a widow's claim for a pension, which was challenged on the basis that her 37-year marriage, which took place in a Sikh temple back in the 1950s, was supposedly void because the temple hadn't been properly registered for marriages at that time.
Okay, 37 years of marriage challenge.
Exactly. But the Court of Appeal found that neither the woman nor her late husband had been aware, back when they married, that the temple wasn't registered. They believed they were complying with the necessary requirements. Since they were unaware of the defect, they could not have knowingly and willfully disregarded the rules.
So their lack of knowledge saved the marriage.
Yes. The marriage was held to be valid. The court also relied on a common law presumption, the idea that after such a long period of cohabitation and the couple holding themselves out to the world as married, the law presumes there was a valid marriage unless there's strong evidence to the contrary. Here, their lack of knowledge meant the challenge failed.
That comparison between Jairus and Bath really highlights just how crucial that knowingly and willfully element is. It protects people who are innocently caught out by procedural errors made by others.
It really does. It shifts the focus onto the party's state of mind regarding the essential legal requirements, rather than just punishing any procedural slip-up automatically.
Okay, that makes sense. What's the next ground for a void marriage under S11?
That's Section 11B. This states that a marriage is void if, at the time of the marriage, either party is already lawfully married or already in a civil partnership.
So this is basically the bigamy rule within nullity law.
Exactly. If you are already legally married or in a civil partnership with someone else, any subsequent attempt to marry or form a civil partnership is simply void from the start.
And this is void even if the person genuinely but mistakenly believed their first spouse or civil partner had died.
Yes. For nullity purposes, the second marriage is void if the first valid marriage or civil partnership is still legally subsisting. An honest belief that the previous partner was dead is not a defense in the nullity proceedings themselves.
Even if it might be a defense in a criminal case.
Correct. It might be a defense to a criminal charge of bigamy, but it doesn't stop the second marriage being legally void. The proper legal route, if you think your spouse might be dead but can't prove it, is to obtain a divorce or perhaps a decree of presumption of death for the first marriage before attempting to remarry.
Right. And finally, under S.11, we have S.1c, which covers polygamous marriages.
Yes. This applies specifically to polygamous marriages entered into outside England and Wales. Such a marriage will be considered void here if either party was domiciled in England and Wales at the time the marriage took place.
Domicile is the key trigger there.
Yes. Domicile is a complex legal concept, basically about where your permanent home is considered to be in law, the country you belong to indefinitely. If that legal home was England and Wales for either person at the time they entered into a polygamous marriage abroad, then that marriage will be void under English law.
Okay, so to quickly summarize the S.1 grounds that make a marriage void, fundamentally invalid from the start: being within prohibited degrees of relationship, too closely related by blood or marriage, either party being under 18, specific defective formalities, but only if both parties knew and willfully disregarded them, already being lawfully married or in a civil partnership, bigamy, and entering a polygamous marriage abroad if either party was domiciled here.
That's a perfect summary of the void grounds under S.1 MCA 1973. These are situations where the state essentially says, this never qualified as a legal marriage in the first place.
Right. Now let's move on to the grounds for avoidable marriage. These are listed in S.12 of the Matrimonial Causes Act 1973. And these are different, aren't they? These marriages are considered valid, they create a legal status, but they can be annulled by a court decree if one of these specific defects existed at the time of the marriage.
Exactly. Most of these grounds relate to a party's capacity or state at the time the marriage was celebrated. There is one important exception which looks at conduct after the marriage, which we'll come to.
Okay, the first ground listed in S.11 is S.1 at A, incapacity to consummate the marriage.
Right. And the first crucial thing to note here is that this ground applies only to marriages between a man and a woman.
Only opposite-sex marriages.
Yes, as point 12 makes that clear. It makes the marriage voidable if it has not been consummated owing to the incapacity of either party to consummate it. Incapacity here means the physical or psychological inability to have sexual intercourse.
What does consummate actually mean in this specific legal context? Is it just any penetration?
No, the courts have defined it quite specifically. It requires ordinary and complete sexual intercourse, as established way back in cases like DVA in 1845. This is generally understood to require erection and penetration, though perhaps not necessarily ejaculation. It's definitely different from the definitions used for adultery or rape.
And it's about incapacity, not just unwillingness or lack of desire.
Yes, it must be an inability. Importantly, sterility. The inability to conceive children is not the same as incapacity to have intercourse, and sterility is not a ground for nullity. Also, the use of contraceptives does not prevent consummation in the legal sense. That was confirmed in Baxter v. Baxter in 1948.
So using a condom doesn't mean the marriage hasn't been consummated legally? What about the incapacity itself? Can it be physical or mental?
It can be either. Physiological incapacity might be due to a physical abnormality or injury. Psychological incapacity is often described using terms like invincible repugnance, meaning a deep-seated, overwhelming aversion to having sexual intercourse specifically with that spouse. It's not just a general lack of libido or frigidity that affects relations with everyone. It has to be spouse-specific, as seen in Singh v. Singh 1971.
And does the incapacity have to be permanent?
Generally, it must be permanent or incurable. However, incurable can be interpreted quite broadly. If there's a medical or surgical procedure that could potentially cure the condition, but the affected party refuses to undergo it, especially if it involves risk or is against their beliefs, the condition might still be deemed legally incurable, as suggested in SVS 1963.
Okay. The next ground is S.12b, willful refusal to consummate.
Yes, and again, like incapacity, this ground applies only to marriages between a man and a woman, as per S.12. And this is the exception I mentioned earlier. It's the only ground for voidable marriage that is based on events or conduct after the marriage ceremony itself.
Right, because the refusal happens after they're married.
Exactly. It requires that the respondent, the person being petitioned against, has willfully refused to consummate the marriage. Importantly, the petitioner, the person bringing the case, cannot rely on their own refusal.
So one party is willing and able, but the other person simply refuses to have intercourse without a good reason. Is that the essence of it?
That's the core idea, yes. The classic definition comes from Horton v. Horton in 1947. It requires a settled and definite decision come to without just excuse.
A settled and definite decision. Does this require the respondent to have actively turned down opportunities for intercourse?
Usually, yes. It often involves evidence of requests being made and refused over a period. However, the court can look at the overall behavior. There was an interesting case, Ford v. Ford, 1987.
What happened in Ford v. Ford?
The husband was in prison for much of the early marriage, so opportunities for intercourse were obviously very limited just during prison visits. However, his general conduct towards his wife, his letters, and his clear lack of intention to live a normal married life with her were considered sufficient evidence of a settled decision not to consummate. It showed a definite refusal to engage in the marital relationship in its fullest sense, including consummation.
So, behavior can speak louder than words sometimes. What might count as a just excuse for refusing consummation? If there's a good reason, it's not willful refusal.
Correct. The courts have considered a few situations. One key area is where the parties had a civil marriage ceremony, like in a register office, but did so on the clear understanding that it would be followed by religious ceremony, which was important to one or both of them.
Oh, like a two-part wedding.
Exactly. If one party then refuses to go ahead with the agreed religious ceremony, the other party might have a just excuse for refusing to consummate the civil marriage until the full agreed process is completed. We saw this in Kaur v. Singh, 1972.
Kaur v. Singh, what was that about?
It involved a Sikh couple. They had the register office wedding with the intention of having a full Sikh religious ceremony afterwards. The husband then refused to arrange the religious ceremony. The wife successfully petitioned for nullity based on his willful refusal to consummate, essentially. His refusal to proceed with the religious part gave her a just excuse for not consummating the civil part yet. Viaje 1989 is another similar case.
Interesting. What about an agreement not to consummate? Can that be a just excuse?
Generally, no. An agreement between spouses not to consummate their marriage is usually considered void as being against public policy, as established in Brody v. Brody, 1917. Marriage is presumed to involve consummation.
But there's an exception.
Yes, there's a narrow exception sometimes called companionate marriage. This typically involves elderly couples who marry primarily for companionship with no intention or expectation of sexual relations, and they specifically agree beforehand that they will not consummate the marriage. In such limited circumstances, that prior agreement might be seen as a just excuse if one party later refuses intercourse, as seen in cases like Morgan v. Morgan, 1959, and Scott v. Scott, 1959. But it's a very specific scenario.
Okay, so these first two voidable grounds under S2, incapacity and willful refusal, are quite specific and only apply to opposite-sex marriages.
That's right. They relate directly to the physical aspect of consummation.
Let's move on to S.1 pose. This seems broader. Lack of valid consent, whether owing to duress, mistake, unsoundness of mind, or otherwise.
Yes, this is a really crucial ground, covering situations where one party didn't truly agree to the marriage freely and with understanding. Let's break down the elements. Duress is a major aspect, particularly relevant in the context of forced marriage.
What's the legal test for duress? Does someone have to be physically threatened?
No, not necessarily. The legal test is essentially subjective. Did the fear or pressure exerted on the party override their true intention to marry? Was their will overborne so they couldn't give free consent?
So it focuses on the effect on the person.
Exactly. And this was a significant clarification made by the Court of Appeal in Hirani v. Hirani back in 1982. They explicitly rejected the older, stricter test from cases like Sector v. Sector 1971, which often required a threat amounting to danger to life, limb, or liberty.
What happened in Ronnie?
In Hirani v. Hirani, a young woman agreed to an arranged marriage primarily out of fear of being ostracized and made homeless by her parents if she refused. The Court of Appeal held that this intense social and emotional pressure was sufficient to constitute duress, even though there wasn't a direct physical threat. The key was that her will was overborne.
So emotional or psychological pressure can be enough.
Absolutely, if it's severe enough to vitiate consent. And the pressure doesn't necessarily have to come from the other spouse or their family. It can arise from external circumstances or third parties, as suggested in cases like Buckland v. Buckland, pressure from police involved, or even the complex political situation in Sector v. Sector.
This leads us directly to the very serious issue of forced marriage, which unfortunately still occurs.
It does, and it's absolutely vital here to make the distinction between an arranged marriage and a forced marriage. An arranged marriage is a process, often involving family input and support, where individuals are assisted in finding a suitable partner, but crucially, they ultimately give their full and free consent to the marriage. It's a respected cultural practice for many. A forced marriage, however, is completely different. It's a fundamental abuse of human rights. It's where one or both parties do not consent to the marriage and are coerced into it through significant physical, psychological, emotional, financial, or sexual pressure or threats. It is, as one judge put it, an abomination.
And lack of consent under S.1c can also arise if a person simply doesn't have the mental capacity to understand what they are agreeing to, right? Particularly thinking about vulnerable adults.
Yes, that's covered under unsoundness of mind within S.1c, or potentially under the broader mental disorder ground in S.1c. There have been difficult cases involving individuals with learning disabilities or other conditions affecting capacity. Cases like Re-SA 2006, involving a young deaf woman with learning disabilities, and MVB 2006, concerning a woman with severe learning disabilities, highlight this.
What's the test for capacity in this context?
The courts have to assess whether the individual had the capacity to understand the nature of the marriage contract itself and its fundamental duties and responsibilities. Mr. Justice Munby, as he then was, summarized it well in Sheffield City Council v. 2005. He said, capacity is about understanding the contract you are entering into, not necessarily about being able to weigh up all the detailed pros and cons of that specific marriage partner. It's about grasping what marriage is in legal terms.
And the law has taken specific steps to combat forced marriage beyond just nullity.
Yes, definitely. While a forced marriage is voidable for lack of consent under S.1c, as seen in PVR 2003, other protections exist. The Forced Marriage Civil Protection Act 2007 introduced forced marriage protection orders, FMPOs. Courts can make these orders to protect someone who is being forced or has already been forced into a marriage.
And it's also a criminal offense now.
Yes, the Antisocial Behavior Crime and Policing Act 2014 made forcing someone into marriage a specific criminal offense. It also criminalized breaching an FMPO.
Okay, back to S.1 twin C. What about mistake? What kinds of mistakes can make a marriage voidable?
A mistake is a valid ground, but only in two very specific situations. Firstly, a mistake as to the identity of the person you are marrying. This means you literally married someone believing them to be someone else entirely.
Like an imposter scenario.
Exactly. Examples include the case of C&D 1979, where a woman married someone she believed was male, but who was biologically female, intersex, or Militante v. Ogunwamoju 1993, which involved an identity swap where one person stood in for another at the ceremony. Critically, though, a mistake about a person's attributes, like their wealth, their health, their social status, their character, or even their name if you still knew who they physically were, is not a valid ground for mistake.
So marrying someone thinking they're rich when they're actually poor doesn't count. But marrying someone thinking they're person A when they're actually person B does count. What's the second type of mistake?
The second valid ground is mistake as to the nature of the ceremony itself. This applies if a party genuinely believed the ceremony they were participating in was something fundamentally different from a legal marriage ceremony.
Like what?
Maybe they thought it was just a religious blessing, or a betrothal ceremony that didn't create legal ties yet, like in Valier v. Valier 1925, or perhaps an act of religious conversion that they didn't realize also constituted a marriage, Metha v. Metha 1945. However, a mistake about the legal consequences of marriage, what marriage does legally, like affecting property rights or inheritance, does not make it voidable. Way v. Way 1950, Messina v. Smith 1971. You have to misunderstand the ceremony itself, not just its effects.
Okay. And unsoundness of mind is also listed under S.1 C.
Yes, this is the third specific element mentioned. It requires establishing that at the time of the marriage ceremony, a party was incapable, due to their mental state, of understanding the nature of marriage and the duties and responsibilities it creates. The leading case here is in the estate of Park, 1954. This is quite a high bar, focused specifically on capacity at the moment of contracting the marriage. As we noted, the separate ground in S.1D for mental disorder is broader.
And the phrase or otherwise at the end of S.20 C, what does that cover?
It's a sort of catch-all for any other residual situations where consent might be vitiated in the way not covered by duress, mistake, or unsoundness of mind. While it's not commonly used, historical examples sometimes given include situations where a party was so heavily intoxicated by alcohol or drugs at the time of the ceremony that they were rendered completely incapable of understanding what they were doing or giving valid consent. Sullivan v. Sullivan, 1818.
Okay, that covers the complex ground of lack of consent. Let's look quickly at the other specific grounds listed in S.102. What about S.2T, mental disorder? How is that different from unsoundness of mind under C?
Section 12D is broader. It makes a marriage voidable if, at the time of the marriage, either party, although potentially capable of giving valid consent in the narrow S.1C sense, i.e., they understood the contract, was nevertheless suffering from a mental disorder within the meaning of the Mental Health Act 1983, and it was of such a kind or extent as to make them unfitted for marriage.
Unfitted for marriage. That sounds quite judgmental. What does it mean practically?
It's interpreted as meaning they might understand they are getting married, but their condition is such that they realistically cannot cope with the ordinary stresses, duties, and responsibilities of married life. It's a difficult balance the law tries to strike, protecting vulnerable individuals, but not preventing people with manageable conditions from marrying if they have capacity. Again, the test from Sheffield City Council VE 2005 about capacity to understand the contract is relevant background here.
Okay. Next is S.20AE, which lists venereal disease.
Yes. This ground makes a marriage voidable if, at the time of the marriage, the respondent was suffering from a venereal disease in a communicable form. A key point here, as we'll see when we discuss civil partnerships, is that this ground does not apply to civil partnerships.
Only marriage. And is it clear what counts as venereal disease today? Does it include things like HIV?
That's actually been a point of some uncertainty and debate in legal commentary and potentially in unreported cases. The legislation hasn't been updated to explicitly clarify this regarding modern STIs like HIV.
Okay, and S.12F is pregnancy per allium.
Yes, which simply means pregnancy by another person. A marriage is voidable if, at the time of the marriage, the respondent, usually the wife, was pregnant by someone other than the petitioner, the husband. Like the venereal disease ground, this ground also does not apply to civil partnerships.
Right, so S.1 T, E, and F are specific to marriage and seemingly only apply in practice to opposite-sex marriages given the context.
That's correct.
Finally, we have S.112G and S.12. These relate to transgender people and the Gender Recognition Act 2004. This must reflect a significant evolution in the law compared to how things used to be.
Absolutely. Historically, English law followed the very strict biological approach established in the landmark, but now largely superseded. Case of Corbett v. Corbett in 1971.
Corbett v. Corbett, what did that decide?
It held that, for the purposes of marriage, a person's sex was determined solely by biological factors present at birth: chromosomes, gonads, genitals. Consequently, a marriage between a man and a transgender woman who had been assigned male at birth was held to be legally void because, in the eyes of the law at that time, she was still considered male, making it an invalid same-sex marriage.
So legal recognition completely failed to match the lived reality for trans people under that old rule.
Exactly. It caused significant hardship and was eventually found to be incompatible with the European Convention on Human Rights, particularly the right to respect for private life and the right to marry, by the European Court of Human Rights in cases like Goodwin v. UK 2001 and IV UK 2002.
And those rulings prompted the UK Parliament to act.
Yes, they led directly to the enactment of the Gender Recognition Act 2004, usually called the GRA 2004. This act allows individuals to apply for a Gender Recognition Certificate, or GRC. If granted, a GRC legally changes the person's gender for most purposes under UK law.
So how did the S.12 grounds for nullity fit in with GRCs now, especially since same-sex marriage is legal?
Well, the legal landscape was further transformed by the Marriage Same-Sex Couples Act 2013. Since that act, the sex of the parties is no longer generally relevant to the validity of a marriage itself. However, the S.12 nullity grounds relating to GRCs remain. Section 12 makes a marriage voidable if, at the time of the marriage, the respondent had already acquired their legal gender under the GRA 2004, i.e. they had a full GRC.
Why would that make it voidable if gender doesn't matter for validity anymore?
It essentially provides an out for the other spouse if they were unaware of their partner's trans history or acquired gender status when they married. It allows them to seek an annulment if they don't wish to continue the marriage upon discovering this information. Similarly, Section 12(1)G makes the marriage voidable if an interim GRC is issued to either party after the marriage has already taken place. This covers situations where someone transitions during the marriage. Again, it gives the other spouse the option to seek nullity if they do not wish the marriage to continue in light of their partner's gender recognition process.
So these grounds give the other party an option if the situation changes regarding gender recognition, or if they were unaware of the situation at the time of marriage.
Yes, it's about navigating the legal implications of gender transition within the context of an existing or newly formed marriage, providing a specific route to annulment for the spouse who did not transition or was unaware. And getting the timing right regarding the GRC is critical, as demonstrated in the case of P, transgender applicant 2019, where a marriage was found void because the necessary GRC hadn't been obtained before the marriage took place in the context of the specific laws applicable at that time.
Okay, so the S.112 grounds for voidable marriage are quite a mixed bag. Incapacity or refusal to consummate, opposite sex only, lack of valid consent, covering duress, mistake, unsoundness of mind, mental disorder, making someone unfitted, venereal disease or pregnancy by another, opposite sex only, and these specific issues around gender recognition certificates. These are all defects that make the marriage annullable, but it's treated as legally valid until that happens.
That's a good summary of the voidable grounds under S.110 MCA 1973.
Now, even if one of these grounds for a voidable marriage technically exists, I understand there are certain bars that can actually prevent a court from granting the decree of nullity.
That's correct. These are set out in S.33 of the MCA 1973.
And it's really important to remember, right, that these bars only apply to voidable marriages. They do not apply to void ones.
Absolutely crucial distinction. Section 13 makes that explicit. A void marriage is a legal nullity from the start, so there's no concept of a bar preventing a court from declaring that reality. The bars only operate to potentially save a marriage that is merely voidable.
Okay, so what's the first bar listed in SPAN 134? It's called approbation.
Yes, approbation. This essentially means the petitioner has, by their conduct, accepted or approved of the marriage despite knowing it was voidable. It requires two distinct elements to be satisfied.
What are they?
Firstly, the court must be satisfied that the petitioner, knowing they had the right to have the marriage annulled, behaved towards the respondent in such a way that it led the respondent to reasonably believe that the petitioner would not seek an annulment.
So you knew you could get out, but you acted like everything was fine, and the other person relied on that belief.
Yes, that's the first part. And secondly, the court must also be satisfied that it would be unjust to the respondent to grant the decree of nullity now, given that reliance.
Okay, sounds like a fairness principle. Is this bar often successful?
Actually, it's very rarely successfully argued in modern cases.
Oh, why is that?
Mainly because, as we'll discuss more under effects, comprehensive financial provision is now available upon nullity, pretty much the same as upon divorce. This was confirmed in DVD back in 1979. Since the respondent can usually get financial orders even if the marriage is annulled, it's much harder to argue that granting the annulment would be seriously unjust to them. It significantly weakens that second limb of the approbation test.
Right, the potential injustice is mitigated by the availability of financial orders.
Exactly. Although perhaps, as Cretany and Probert suggested, it might still have some theoretical relevance in those niche companionate marriage cases we mentioned earlier, where financial issues might be less central.
Okay. The next bar relates to time limits
Mhm.
under S.3342 and S.334.
Yes, and this is an absolute bar for certain grounds. For petitions based on S.1 through lack of consent, S.2 mental disorder, S.10E venereal disease, and S.10 F pregnancy per allium, the proceedings for nullity must be initiated within 3 years of the date of the marriage.
3 years? That seems quite short. And it's an absolute bar.
It's an absolute bar subject to one very narrow exception. If you miss this 3-year deadline, you simply cannot seek nullity based on those specific grounds anymore.
So if I discover 3 years and one day after my wedding that my spouse lacked capacity due to unsoundness of mind at the time, I can't get it annulled on that ground.
Not on that specific ground, no. The 3-year window has closed. The purpose is to promote certainty in marital status after a reasonable period.
What's the narrow exception you mentioned?
The exception is under Assent 134. It allows the court to grant permission or leave to bring proceedings after the 3-year period if the petitioner suffered from a mental disorder at some point during that initial 3-year period, and the court considers it just to allow the case to proceed despite the delay. It's quite specific.
Okay, so the 3-year time limit is pretty strict, mainly there to ensure legal certainty about whether a marriage is valid or not after a few years have passed.
Yes. And it's interesting, actually, how we've seen courts sometimes use the non-marriage concept, which doesn't have these time limits, to provide a remedy in situations where nullity is time-barred under S.132. Cases like BVI 2010 and SHV NB 2009 involve situations where annulment was time-barred, but the ceremony was considered so fundamentally flawed, for example, due to extreme lack of consent or formality issues, that the court felt able to declare it a non-marriage instead, effectively finding a way around the time bar in those very specific, egregious circumstances.
Ah, showing how the different categories can sometimes interact or provide alternative routes.
Yeah.
What's the final bar? It's about knowledge of the defect under S.13.
Yes. This bar applies only to 2 specific grounds: S.12e, venereal disease, and S.1 free, pregnancy per allium.
Just those two.
Just those 2. For these grounds, the petitioner is barred from getting an annulment if the court is satisfied that the petitioner knew about the relevant facts at the time of the marriage. The petitioner essentially has to prove they were ignorant of the venereal disease or the pregnancy by another person when they got married.
So if you knew your spouse had that condition or was pregnant by someone else when you went through the ceremony, you can't then use that fact later to try and annul the marriage.
Exactly. You can't consent to marry knowing those facts and then try to undo it later based on those same facts. And you need to be ignorant of all the material facts, for example. Simply knowing your wife was pregnant isn't enough to bar a claim under S12F. You must have known she was pregnant by another man.
Okay, that makes sense. It prevents someone from agreeing to a situation and then changing their mind based on the very thing they agreed to.
That's the principle behind that particular bar in
Real.
S.133.
Right, so we've covered the void grounds, the voidable grounds, and the bars that can prevent avoidable marriage being annulled. S13. What actually happens once a court does grant a decree of nullity? What are the legal effects?
Well, historically, the consequences of nullity used to be drastically different from divorce. For a void marriage, it was as if it never happened, which could lead to really complex issues. Children born during the marriage were considered illegitimate, though legislation has largely fixed that now. And trying to unscramble property and financial dealings done on the assumption of a valid marriage was a nightmare.
And voidable marriages were treated as valid until the decree.
Yes, which also had its own set of consequences. But the key point now is that statute law, primarily the Matrimonial Causes Act 1973 itself, has largely assimilated the practical consequences of nullity with those of divorce, especially regarding financial provision and the status of children.
Okay, so financially, getting an annulment is often similar to getting divorced nowadays.
Very often, yes.
Ah,
Sections 23 and 24 of the MCA 1973 give the courts essentially the same wide powers to make financial provision orders, things like periodical payments, spousal maintenance, lump sum orders, property adjustment orders like transferring houses, pension sharing orders when they grant a decree of nullity, whether void or voidable, as they have when granting a decree of divorce.
So the court can redistribute assets and order maintenance just the same.
Pretty much, although there was an interesting and slightly controversial public policy debate that emerged in cases involving bigamous marriages, which are void. In Whiston v. Whiston in 1995, the Court of Appeal initially denied financial provision to a wife who had knowingly entered into a bigamous marriage.
Why, if the statute gives a power?
The court felt it was contrary to public policy to allow her to benefit financially from her own criminal act of bigamy. She was founding her claim on her illegal conduct.
But was that approach followed consistently?
Not entirely. In a later case, Rampal v. Rampal in 2001, the Court of Appeal distinguished Whiston. In Rampal, financial claims were allowed where it was the other party who knew the marriage was bigamous, or perhaps where both knew. It suggests the public policy bar from Whiston might be limited to cases where the person seeking money was the one who knowingly committed bigamy, and maybe not apply if they were the innocent party regarding the invalidity. The courts seem generally reluctant now to let public policy override the clear statutory power to make financial orders, aiming to avoid unfairness.
Okay, so financial remedies are generally available. What about inheritance rights if one partner dies?
Yes, the Inheritance Provision for Family Independence Act 1975 allows a former spouse, and explicitly includes someone whose marriage was annulled as void or voidable, to apply for financial provision from their deceased partner's estate, provided the marriage ended by death or decree before the death occurred in some circumstances.
Right. Let's just quickly revisit the status of the marriage up until the decree is granted. This seems really important for things that happen during the relationship, legally speaking.
It is absolutely critical. For a void marriage, remember, it never had any legal existence. So any transactions or legal statuses that were based on the assumption it was valid can potentially be unraveled or declared invalid retrospectively.
Okay. But for avoidable marriage, it's different.
Completely different, thanks to Section 16 of the MCA 1973. This is a key section. Section 16 states that where a decree of nullity is granted in respect of avoidable marriage, the marriage shall be treated as if it had existed and been valid for all purposes up until the date the decree absolute of nullity is made.
So if I entered avoidable marriage, legally speaking, the period between the wedding ceremony and the final decree of annulment is treated as if I was actually genuinely married.
Exactly. It's treated as a valid marriage during that time. This has real practical consequences. Take the case of Ward v. Secretary of State for Social Services, 1990.
What happened in Ward?
A widow was receiving a widow's pension. She then remarried. Her remarriage automatically terminated her right to the pension. Later, her second marriage was annulled because it was voidable due to her second husband's incapacity. She tried to argue that because the second marriage was annulled, it was as if it never happened, so her widow's pension should be reinstated.
But the court said no.
The court said no. Because of Section 16, her voidable second marriage was treated as valid until it was annulled. Therefore, her widow's pension had been validly terminated by that remarriage, and the later annulment couldn't undo that termination retrospectively.
Wow. So S-140 really preserves the legal effects of the voidable marriage during its existence.
It does. Another example is Roberts, 1978, where entering into a voidable marriage was held to have revoked a prior will made by one of the parties because the marriage was legally valid at the time it took place, and marriage automatically revokes a will unless made in expectation of it. The later annulment didn't change that effect.
That Section 16 point really clarifies the difference in their legal status before any court intervention. The voidable marriage actually has real legal effects during its existence, however brief that might turn out to be.
Precisely. It's a crucial practical difference stemming from the voidable distinction.
Okay. Now, let's turn our attention to civil partnerships. These were introduced, of course, by the Civil Partnership Act 2004, often called the CPA 2004.
Yes. The CPA 2004 was a truly landmark piece of legislation. It was introduced primarily to allow same-sex couples to obtain legal recognition for their relationships, granting them rights and responsibilities that were largely equivalent to those of married couples. It was a major step in addressing decades of discrimination.
And it's important to remember the historical context, isn't it? It wasn't until 1967 that sexual relations between men were even decriminalized in the UK.
Absolutely. The CPA 2004 provided a formal legal framework for same-sex couples where none had existed before.
How is a civil partnership actually formed? Is the ceremony exactly like a civil marriage ceremony?
The process leading up to it is very similar to a civil marriage. You have to give notice, there's a waiting period, and the registration usually takes place at a register office or an approved premises. However, there's a key difference in the ceremony or registration itself.
What's the difference?
Unlike in a civil marriage ceremony, where specific declaratory and contracting words must be spoken, there are no specific prescribed words or vows required to form a civil partnership. Section 2.1 of the CPA 2004 simply requires the two parties to sign the civil partnership document called the schedule in the presence of the registrar and two witnesses.
That's quite a significant difference. No mandatory verbal commitment, just the signing of the document.
Yes, it was designed to be a purely secular registration-based process without specific ceremonial requirements.
And people in civil partnerships can now convert their partnership to a marriage if they want to.
Yes, the Marriage Same-Sex Couples Act 2013, which introduced same-sex marriage, also included provisions allowing existing civil partners to convert their partnership into a marriage through a simple administrative process.
Now, do the concepts of void and voidable apply to civil partnerships in the same way they apply to marriage? Can a civil partnership be declared a nullity?
Yes, they do apply in a very parallel way. The CPA 2004 contains mirroring provisions for nullity in sections 49 and 50. A civil partnership can be either void or voidable, and the grounds are very similar, though not identical, to those for marriage nullity.
Okay, let's look at void civil partnerships first. What makes a civil partnership void under S.49 CPA 2004?
The grounds for a void civil partnership are largely the same as for a void marriage. So that includes being within the prohibited degrees of relationship, either party being under 18, failure to comply with certain formal requirements with an equivalent knowingly and willfully test, and one of the parties already being lawfully married or in another civil partnership.
Sounds very similar. Is there any key difference?
Yes, there was a
Yeah.
fundamental difference based on the original purpose of the Act. Section 49 of the CPA 2004 originally made a civil partnership void if the parties were not of the same sex. This was the cornerstone of the 2004 Act. It was exclusively for same-sex couples.
Right, the exact opposite of the historical bar to same-sex marriage. Okay, what about voidable civil partnerships under S.58 CPA 2004?
Again, the grounds for a voidable civil partnership mirror many of the grounds for voidable marriage. These include lack of valid consent due to duress, mistake, unsoundness of mind, etc. One party suffering from a mental disorder, making them unfitted for civil partnership, and one party being pregnant by a third party at the time of the formation of the partnership. Pregnancy per alium.
Are all the voidable grounds for marriage included here? What about consummation or VD?
No, and this is another crucial difference between marriage nullity and civil partnership nullity. The grounds of incapacity to consummate and willful refusal to consummate S12A and B of MCA in 1973 do not apply to civil partnerships. They were never part of the CPA 2004 framework.
Okay, no consummation requirement or ground for civil partnerships.
Correct. Similarly, the ground of suffering from venereal disease in a communicable form, S12E of MCA 1973, also does not apply to civil partnerships.
So to summarize the key differences for voidable grounds, no consummation grounds, incapacity or refusal, and no venereal disease ground for civil partnerships.
Exactly. Those specific grounds are unique to marriage nullity.
And the effects of getting a civil partnership annulled, are they the same as for marriage?
Yes, the legal effects, particularly regarding financial provision under Schedule 5 of the CPA 2004, which largely mirrors MCA 1973, and the treatment of the partnership status up to the decree under S.54 CPA 2004, equivalent to S.16 MCA 1973 for voidable partnerships, are designed to be parallel to those for marriage nullity.
Okay. Now, we mentioned that civil partnerships were initially only for same-sex couples,
Hmm.
but that changed quite recently following a major court case.
Yes, a very significant development indeed. In 2018, the UK Supreme Court gave its judgment in the case of R on the application of Steinfeld and Kuyten v. Secretary of State for International Development.
Steinfeld and Kuyten, what was that about?
It was brought by an opposite-sex couple, Rebecca Steinfeld and Charles Kuyten, who wanted to enter into a civil partnership rather than get married. They argued that denying opposite-sex couples the option of a civil partnership while offering it to same-sex couples and offering marriage to both was discriminatory and breached their rights under the European Convention on Human Rights.
And the Supreme Court agreed.
Yes, the Supreme Court unanimously agreed with them. They declared that the provisions in the CPA 2004 limiting civil partnerships to same-sex couples only were incompatible with the ECHR.
So that ruling forced the government to change the law.
It did. Parliament responded by passing the Civil Partnerships, Marriages and Deaths, Registration, etc. Act 2019. This act amended the CPA 2004 to extend civil partnerships to opposite-sex couples as well.
When did that come into effect?
Regulations were made under the 2019 Act, and the first opposite-sex couples were able to register their civil partnerships in England and Wales in December 2019.
So now opposite-sex couples have a choice. They can get married or they can enter a civil partnership.
Exactly. It provides an alternative legal framework for formalizing their relationship, which some couples prefer for various reasons. Perhaps ideological objections to marriage, or simply preferring the perceived equality of the civil partnership model.
It really shows how the law governing formal relationships is constantly adapting, doesn't it? Often driven by human rights principles and responding to changing societal views and needs.
It's a very clear example of legal evolution in response to both societal shifts and direct legal challenges based on equality and non-discrimination.
Are there any other potential future directions being discussed for civil partnerships? Any talk of extending them further?
Well, there have been some proposals floated, most notably a private member's bill introduced by Lord Lexton in the House of Lords a few times, which proposed extending civil partnerships to siblings, specifically targeting cohabiting siblings, often elderly ones, who care for each other long term.
Civil partnerships for siblings. What would be the purpose?
The argument is often about providing legal recognition and, perhaps more importantly, associated rights, particularly concerning inheritance tax exemptions or tenancy succession, for siblings who share a home and finances over many years, similar in some ways to married couples or civil partners.
Has that proposal gained much traction?
So far, it has not gained government support and hasn't progressed into law. There are various arguments against it concerning the fundamental nature of civil partnerships as being for couples and potential complexities. So while it's been debated, it doesn't seem to be on the immediate horizon for reform currently.
Right, so a lot has changed, especially with opposite-sex civil partnerships, but there's still potential for further evolution or debate down the line.
The law in this area is certainly not static. It continues to be debated and refined.
Okay. We have covered a tremendous amount of ground in this deep dive today. It's been really detailed.
It has. We've looked at the fundamental requirements for valid marriages and civil partnerships. We've explored the definitions and, crucially, those vital distinctions between void relationships, which legally never existed, voidable relationships, which were valid until annulled, and that more recent concept of non-marriages, which don't even count as a legal attempt.
And we've gone through the specific grounds for making a marriage void under S.11 MCA 1973, things like prohibited degrees, age, certain formalities if knowing and willful, bigamy, and the grounds for making a marriage voidable under S.11 like incapacity or refusal to consummate opposite sex only, lack of valid consent, mental disorder, VD, pregnancy per allium, and the GRC issues.
Exactly. And we've looked at the parallel grounds for civil partnerships under the CPA 2004, highlighting the key differences, the initial same-sex requirement for void partnerships, now removed for future ones but relevant for past ones, and the significant absence of consummation and VD grounds for voidable civil partnerships.
We also examined the bars set out in S.3 MCA 1973 that can prevent a voidable marriage from being annulled ab probation, rarely successful now, the strict 3-year time limit for most grounds, with that narrow mental disorder exception, and the knowledge bar for the VD and pregnancy grounds. And we stressed again that these bars do not apply to void marriages.
Absolutely. And we discussed the effects of a nullity decree, particularly how statute law has now largely assimilated the consequences with divorce, especially regarding the court's wide powers to make financial provision orders under SS 23 and 24 MCA 1973. But we also noted the continuing importance of the legal status distinction before the decree, especially S.1c MCA 1973, which treats avoidable marriage as valid until annulled.
And we've tried to anchor these legal rules in some of the key cases that illustrate how these principles are applied, mentioning Darrenville for the core voidable distinction, Hudson v. Lay and the Actor v. Consaga for non-marriage, Pew v. Pew for the minimum age rule, Gurace and Bath for defective formalities, and that crucial knowingly and willfully test.
Hirani and the forced marriage cases for duress and lack of consent, Corbett v. Corbett, though historically important, now superseded on its main point, and the GRA cases for transgender individuals, Whiston and Rampal, showing the nuances around public policy and financial provision in bigamy cases, and of course Steinfeld and Kaiden, which led to opposite-sex civil partnerships. Remembering the principles from these key cases is vital for seeing how the law actually operates.
And that application is absolutely crucial, isn't it? Especially if you, listening, are preparing for exams based on this material. Being able to look at a problem scenario, identify the potential defect, work out if it makes the relationship voidable or perhaps a non-marriage, then consider if any bars apply for voidable, and finally advise on the likely consequences. That's the practical legal skill these rules are all about.
Precisely. And understanding the historical context, why these rules developed, and the ongoing debates, like whether voidable marriage grounds are still necessary or should be abolished, provides that deeper analytical perspective. It helps you understand the relevance and potential future direction of this area of law, showing how it's a living thing, constantly responding to social change, human rights arguments, and judicial interpretation.
This has been a truly comprehensive deep dive into the sometimes quite complex but always fascinating rules governing the validity of formal relationships under English law.
It really highlights the law's intricate attempt to define boundaries, regulate formation, and provide remedies within the incredibly complex and personal world of human relationships. It's always a delicate balancing act between formal requirements, individual autonomy, and the need for legal certainty.
Definitely a lot to consider there. Thank you so much for joining us for this deep dive.
We sincerely hope this detailed exploration has been valuable for your understanding of this complex topic. And just as a reminder, this deep dive was based on materials from the University of London, made available for educational purposes, and is brought to you by Sinorbit Academy, Sri Lanka.
And to all our listeners, particularly those facing exams on this material and family law, we wish you the very best of luck.
Yes, very good luck.